Hi everyone! Welcome to my channel. Always remember, ignorance of the law excuses no one. This is Legally Engineer. Consent as an essential requisite of a contract. Now we proceed with the object of contracts. Ano ba ito, Attorney?
So the object of a contract is its subject matter under Article 1318 of the New Civil Code. In reality, every contract has the obligation created as its object. However, since settled is the rule that contracts cannot exist without a valid obligation, then it may be gainsaid that the thing, service, or right, which is the proper object of the obligation, is also the object of the contract.
So, the requisites of things as object of a contract.
Yes.
For things to be the very object of contract, the following requisites must be present. First, it should be within the commerce of men, meaning it can legally be the subject of any commercial transaction.
Yes. So ano ba yung mga not in the commerce with outside the commerce of men, kagaya ng mga outer space, sun, planets, so they cannot be a valid subject matter of any commercial transaction.
They're not within the commerce of men. Yung tipo ba, magbentahan kami ng lupa sa moon. Hindi pwede yun because it's beyond the commerce of men. Second, the things must not be impossible either legally or physically. That's the reason why we've discussed to you legally or physically impossible things. So, bawal ang legally or physically impossible as an object of the contract. Third, the thing must be in existence or at least capable of coming into existence. So, that this can be, you can read this through articles 1461, 1493, and 1495 of the Civil Code.
So, example niyan, yung it must be in existence or at least capable of coming into existence. Yung mga, for example, mangingitlog pa lang yung manok mo, tapos binibenta mo na yung itlog.
Pwede.
At
least capable of coming into existence. Halimbawa, yung bibenta ko sa iyo yung mga aanihin kong palay. Kita mo naman, sumusuli pa lang. Pero, capable of coming into existence. No?
It can be a valid subject of the contract.
Pang-apat, it must be determinate or determinable without the need of a new contract between the parties. That's according to Article 1349 and 1460, Paragraph 2 of the New Civil Code. So, dapat determinate, at least determinable. Kung ilan,
yung
quantity, and the quality of the object itself. So,
those are the requisites of things as object of contracts. What about the requisites of services as object of contract?
So again, services naman, first, the service must be within the commerce of men. Second, the service must not be impossible either physically or legally. Okay. And then third, it must be determinate or at least capable of being made determinate as a service. No? Yes. So take note of those requisites.
So, what are those objects which cannot be an object of the contract?
Yun ang mahalagang pag-usapan. Alin yung mga hindi pwede. So, una, lagi naman to, if it's contrary to law, morals, good customs, public policy, or public order. Halimbawa, illegal drugs. Malinaw na sinasabi, hindi pwede maging object of a contract yan. Okay? Kung ito ay illegal nga, prohibited. Pangalawa, indeterminable as to their kind, no? Pag hindi mo ma-determine ano ba yung kind ng object of the contract ngayon. Kasi in that case, hindi magiging definite, no? Hindi magiging definite, okay? And if it's outside the commerce of men,
cannot be subject of any commercial transactions. Pang-apat, intransmissible rights. Cannot be object of contracts. Intransmissible nga. Hindi pwedeng i-transmit yung right nung assignor.
To the assignee. Fifth, future inheritance except when authorized
by law. O yan, future inheritance. Hindi mo pa namamana, pero Pinagbili mo na.
Parang pinapatay
Oo,
mo na.
hindi pa namamatay yung magulang mo, for example. May mamanahin ka, hindi pa namamatay. Yung mamanahin mo, na ipagbili mo na agad.
Pwede yun. Except of course when authorized by law nga. Okay? So take note of that. Article 1347, paragraph 2. No contract may be entered into upon future inheritance except in cases expressly authorized by law.
So, what might not be the object of a contract is future inheritance. What about future things? Can this be a valid object of a contract? Answer is yes. Pwede ang future things. Kaya kanina, sabi kanina yung capable of coming into existence. O kaya capable of being determinable.
So, balikan ko lang yung kanina sa Article 1347, no? Para yung inheritance ay maging valid object of a contract. Yung succession niyan, dapat ay inopen na. And the only time kasi na ma-open ang succession kapag
the time of the death of the decedent.
On the demise of the decedent. So, kung kayo may hinihintay naman na ay hintayin nyo munang
matay.
mag-death.
So, then pa lang
mag-a-act. Ako ay wouldn't wish.
Yes, mas mahal ko yung
ang dami mong mamanahin.
Mas mahal ko yung pagmamanahan ko.
Wow.
Oo. Kesa sa mamanahin ko.
Ako na mapaisip ako. Joke lang. Hindi ako kasi wala naman akong mamanahin.
Ako din, wala naman akong mamanahin.
Wala din naman kami talaga. So, wag na lang. Utang.
It depends.
Baka mapunta tayo sa succession.
It depends.
Okay. So, this future inheritance is an exception to the rule that future things can be a valid object of a contract. Okay?
So, impossible things or services, hindi din yan pwedeng maging object of a contract.
So, yung sinabi ni Attorney Uy, yung pang-anim, impossible things or services. Okay? Now, babalikan lang natin ng konti yung kinds of impossibility para naman ma-refresh sa mga bata. Impossibility may be...
So, impossibility may be physical or legal. So, physical, when the thing or service in the very... when the thing or service in the very nature of things cannot exist. So, example, a monkey that talks or cannot be performed. With particular reference to services, the impossibility may be absolute, it may also be relative.
Kailan mo yung absolute na physically impossible ang service?
So, when nobody can perform it since the act cannot be done in any case.
If you can carry 10 sacks of rice on your shoulder at the same time, at one time. So,
relative naman, when it arises from the special circumstances of the case or the special conditions or qualifications of the obligor.
Halimbawa, ay deaf mute, tapos pinapakanta mo.
Hindi naman.
Physically impossible. Legal naman, when the thing or service is contrary to law, morals, with customs, public policy, public order, paulit-ulit yan naman na yan. Okay? Take note of that. So, we're just done with the objects of the contract. Now, we go on with the last essential requisite, which is cause of contract. So, cause of contracts is the essential or more proximate purpose which contracting parties have in view at the time of entering into the contract. And it has its requisites.
Yes, its requisites are the cost must exist, the cost must be true, and the cost must be licit or legal.
Alright, so since nabanggit natin dyan, Attorney Oy, that the cost actually is the proximate purpose in contracting the parties. Ito ba yung motive? Ito na ba yung sinasabing motibo mo?
Yes, yun yung consideration, cost or consideration, why you enter into a contract.
Pero, as in exactly the same ba? Or may pinagkaiba ba tong motive at saka yung cost of contract?
Yes, there is a difference between cost and motive. So, general rule, validity of the contract is not affected by motive of the contracting parties.
Regardless of your motive.
Yes, as long as nandun lahat yung essential requisites, valid yung contract.
That's according to Article 1351 of the New Civil Code. But may exceptions.
May exception tayo when to defraud the creditors is the main motive of the debtor in alienating the property. Such alienation is rescissible. Ayan naman, may nabanggit ng rescissible.
general rule nga is ang motive hindi mahalaga, pero pagdating dun sa point na kaya ibinenta or kaya
because your motive is to defraud
the creditor,
or to evade the payment,
material yung
yes.
motive doon. Pangalawa is when to avoid a threatened injury. Is the motive of a person in giving his consent to the contract. In case of intimidation, the contract is
voidable. So when the motive of a person induced him to act on the basis of fraud or misrepresentation by the other party, the contract is likewise voidable.
So, titingnan ninyo ha, yung again, ang general rule is that motive is not material except in these three instances. Kapag to defraud the creditor, when it is to avoid a threatened injury, or when the motive is
the basis of fraud or misrepresentation with the other party.
Yes.
So, in that case, it magiging rescissible or voidable, as the case may be, yung contract.
Okay. So, now, let's proceed with what we call defective causes and their effects. Paano nga kapag defective yung causes natin? Ano naman effect nila?
So, absence of cause and unlawful cause produces no effect whatsoever.
1352 of the New Civil Code.
Absence of cause and unlawful cause, it will make the contract void. Again, absence of one of the essential requisites will make the contract void.
How about if there is a statement of a false cause in the contract? Attorney Uy, what would be the status of that?
So, statement of a false cause in the contract will make the contract void if there is no other true and lawful cause.
Kasi kung meron namang other true and lawful causes,
then valid.
And that's according to Article 1353 of the New Civil Code. Now, meron tayong din tawag na yung lesyon. No? Ano ba itong lesyon na to? Anong effect nito muna dun sa contract natin?
So, yung lesson, ito naman yung inadequacy of cause for like more than 1/4. So, lesson or inadequacy of cause is valid unless fraud, mistake, or undue influence is present.
So, that's according to Article 1355 of the New Civil Code, which provides that except in cases specified by law, lesson or inadequacy of cause shall not invalidate a contract unless there has been fraud, mistake, or undue influence. Just because there is damage, just because there is insufficiency of cause, does not necessarily mean that the contract will be invalidated. Okay, you just have to look at first kung may existence ng fraud, mistake, or undue influence. Kaya nagkaroon ng lesson or inadequacy of cause. Okay? So, in the absence of thereof, valid yung contract na yan.
Even may inadequacy.
Yes, but in the presence of the fraud, mistake, or undue influence, magiging
rescissible. Magiging rescissible.
Balik mo nga.
Yeah. So,
again, in that case,
lesson or inadequacy will not necessarily make the contract
invalid.
It will not invalidate the contract unless merong fraud, mistake, or undue influence.
Which in that case, the contract would be rescissible.
Kung may fraud, mistake, or undue influence. And there is lesson.
Right, so Attorney Uy, we're just done discussing to the students and to our listeners the general provisions, serious contract, our module 6. And next lecture, ano ba yung inaasahan ng
yung module 7, we have reformation, interpretation of contracts.
And yung last natin would be
the kinds of
defective
contracts.
So, although napag-usapan naman natin through this session, kahapyaw, no? But we will go more into details of defective contracts in our last module. But for now, we hope you've learned the general provisions of contracts, and please make sure to review again your obligations as they are needed in understanding the contracts that we have right now. So, on that note, again, I am Attorney Benedict A. Maralit.
And I am Attorney April M. Uy.
And lagi nagsasabi, ignorance of the law excuses no one. See you next